Hello, my name is Abdullah with ID card number 23010133. I am presenting on behalf of Mr. Javed, the store manager of Amina's Textile Limited, a fabric store in London renowned for its high quality silk and cottons. Recently, Mr. Javed encountered issues with a supplier, Nationwide Fabric Limited, regarding an order for mulberry silk and white cotton fabric. This issue include incorrect quantities and even the substitution of black cotton instead of white cotton, leading to significant frustration and potential business disruption. Today I will explain Mr. Javed's right and remedies under the Sale of Goods Act 1979. Let's summarize the situation. On 15th September, Mr. Javed ordered 30 meters of mulberry silk and 60 meters of white cotton fabric from NF Limited. The delivery was scheduled in three equal installments on the 20th, 23rd, and 26th of September. Payment was to be made 1 week after each installment. However, NF Limited delivered in incorrect quantity and type of goods. They include black cotton instead of white cotton and fell short on the quantity of mulberry silk. Today, as of 23rd September, Mr. Javed have received two deliveries that are non-compliant, and Mr. Javed is considering rejecting all the delivered fabric and cancelling the final installment due on the 26th. Let's go through Mr. Javed's right and option based on the Sale of Goods Act. First, we will look at Section 13 of the Sale of Goods Act 1979. This section specifies that when goods are sold by disruption, they must correspond exactly to that disruption. Mr. Javed ordered white cotton and NF Limited substitutes it with black cotton, which constitutes a clear breach of Section 13. Here the relevant case law mentioned as Remore v. Landauer 1921. In this case, the buyer successfully rejected goods that didn't conform exactly to that agreed disruption despite a minor discrepancy. Given that Mr. Javed case involves a substitutional deviation, white cotton being substituted with black cotton, this strengthens Mr. Javed's right to reject the delivery. Section 13 provides Mr. Javed with solid ground to reject the non-conforming goods, as the goods delivered do not match the specification Mr. Javed ordered. Next, we turn to Section 30 and Section 31 of the Sale of Goods Act, which further support Mr. Javed's position. Section 30 deal with delivery of incorrect quantities. Here, NF Limited failed to provide the specified amount of mulberry silk in both installments. This shortfall constitutes a breach, as buyers are entitled to receive the exact quantity agreed upon. Section 31 addresses contract involving installment deliveries. If one or more installments fail to meet contractual standards, the buyer may reject those installments and potentially terminate the contract. Given that both installments so far have failed to meet the required standard, Mr. Javed has strong ground to reject the goods and cancel the remaining delivery. The relevant case present on this situation is Arcos Limited versus Runanson and Son 1933. This case highlights that even minor deviation from agreed terms in quality or quantity justify rejection. In Mr. Javed's situation, the deviation in quantity and substitution of fabric type are substitutional, strengthening Mr. Javed's case for cancellation. Together, Section 30 and 31 provide clear support for rejecting both the installments Mr. Javed has received so far, as well as cancelling the final installment scheduled for 26th September due to repeated breaches. Now let's consider the de minimis principle. This principle suggests that minor deviation may be disregarded if they are trialed and do not significantly affect the contract. In Mr. Javed's case, however, the breaches involve material aspects of the order, such as fabric type and quantity. Therefore, it is unlikely that the de minimis principles would apply, as the deviations are significant enough to affect the value and utility of the good. For Mr. Javed's business, the fabric substitutions and quantity shortfall go bound what would be considered trivial. The final section we will look upon section 35, which deal with acceptance under section 35. A buyer is considered to have accepted goods if they indicate approval. Use the goods and a way consist with ownership or retain them bound a responsible time without rejecting them. In this situation, Mr. Javed has acted promptly in expressing Mr. Javed's justification, and there is no indication that Mr. Javed has accepted the good by rejecting them immediately after discovering the issues. Mr. Javed has preserved Mr. Javed's right to refuse the fabric that does not comply with the contractual terms. The Conclude the Sale of Goods Act 1979, particularly Section 13, 30, 31 and 35 offers a strong legal basis for rejecting the goods NF Limited delivered as well as cancelling the third delivery due on 26th September. The combination of non-conforming goods, incorrect quantities and deviation in fabric type justifies Mr. Javed's discussion. In particular terms, Mr. Javed will notify NF Limited in writing of Mr. Javed's discussion to reject the goods and cancel the remaining installment. Citing the specific breaches of the Sale of Goods Act that we have discussed, Mr. Javed may also wish to explore the possibility of claiming damages if they breached have lead to any financial losses or disruption to Mr. Javed's business. Thank you so much.